Assalamualaikum warahmatullahi wabarakatuh. This is a Zoom recorded lecture. This is just to cover or to explain about the additional notes for the topic defamation. So this video is to supplement the existing videos on defamation. And the slides belong to Dr. Farhin, and I have done some editing to the slides. So the purpose of this supplementary video is to explain further on and the latest position of qualified privilege, or the acronym for our purpose of discussion is QP. Let's have a look here. Okay, we start with this case. This is a case from common law from UK, decided by House of Lords. The case name is Jamil and Wall Street Journal, reported in the year 2006. So it involved plaintiff and defendant. So who was defendant? Wall Street Journal here. So they published an article in the Wall Street Journal Europe. And what's the effect? To the effect that the Saudi Arabian, what was the content of the article? So basically it gives the impact or implication or gives some impression that Saudi Arabian monetary authorities were monitoring at the US government's request certain banks' account. And this is in connection, in relation with terrorism. This is very serious activity, serious reporting. And then the plaintiff, Abdul Latif Jamil Group, was named as being on the list of such accounts. So obviously, it affects the reputation, the name of Jamil here. So the main company in the group and its president. So Muhammad Jamil here is the president for the main company in Abdul Latif Jamil Group. So they file a suit, say this, file an action for suit. So they sued for libel. So they are suing, the company or Jamil, the president, he was suing Wall Street Journal for libel. And because why? When the article was published in the Wall Street Journal Europe, actually the plaintiff managed to prove to the court that 5 people had read it in UK. Okay, and it started from trial court and then up to Court of Appeal, in which both courts, plaintiff won the case, and then defendant appeal to House of Lords, and House of Lords give decision in favor of defendant. And then as far as the defense was concerned, defendants never rely on the defense of justification, but they rely or they pleaded specifically qualified privilege. And House of Lords agreed to grant such a defense, to allow such a defense. And House of Lords made it clear that the article was very clear, something in relation to terrorism. This is for public interest, even though by doing so, actually defendant had breached the agreement between US and Saudi government, because the monitoring is supposed to be secret, not to be published or whatsoever. And then the court also, House of Lords also observed that the gathering and reporting, actually, this is something which is responsible and fairly done, and it falls squarely within the responsible journalism. And after all, only 5 people had read about it. And it also actually, in other words, House of Lords approve, acknowledge Reynolds privilege. So we want to know what is Reynolds privilege. Reynolds privilege is that the origin is from, it was established in this case, Reynolds and Times newspaper, reported year 2001, also by House of Lords. And this case is very important. This is the landmark case, which established the Reynolds defense or privilege. And what's the, what's the role, what's the significance of this privilege? So it extends the traditional common law qualified privilege to a wider audience. Because if you remember, in our previous video, qualified privilege usually is between the 2 parties. But for Reynolds privilege, it is applicable to a wider audience, provided it is on a matter of public interest. So as far as Reynolds privilege is concerned, defendant needs to show that publication was made responsibly, establishing a duty interest qualified privilege, and to protect responsible journalism. Although actually this particular privilege is not confined only to journalists, but most of the time I mean, overall, okay, it is to protect, okay, to protect a responsible journalism. And how do we determine, okay, what amounts to responsible journalism? So Lord Nichols, in this case, in Reynolds privilege, actually, he has set out 10 specific factors or steps, okay, so that we can say, oh, this is what we say, or this is what amount as responsible journalism. So this is the 10 factors, okay, for responsible journalism. The first one, seriousness of the allegation, nature of the information, source of information, steps taken to verify, so there must be a verification, status of information, how urgent is the matter, okay, whether comment was sought from the claimant, whether the article contained the gist of the claimant's side of the story, the tone and the circumstances of the publication. So all the 10 factors here need to be fulfilled, okay, step by step, basically. So it's not that easy to succeed or to claim under for the subject matter to be to qualify for responsible journalism. Okay, now what's the position in Malaysia? Because it's now that one, the position in UK at common law. So in Malaysia, Reynolds privilege was first used in Anwar Ibrahim and Mahathir Mohamad, okay, attempt by the party to use this defense. But at the federal court refused to leave to appeal, but they just agreed with the decision of Court of Appeal. So starting from this year, 2001, okay, many Malaysian cases have used Reynolds defense, okay, starting from the case of Anwar Ibrahim and Mahathir Mohamad. And then in year 2015, okay, the federal court endorsed, okay, expressly endorsed the application, okay, the usage of Reynolds privilege in the case of Dr. Syed Azman, others, and Datuk Seri Haji Ahmad bin Said. And the latest one, the case that we want to discuss today is what happened in the year 2018, the reported case in the year 2018. Okay? It was made clear because in year 2015, it was endorsed, but it's not really clear how to apply. But in the year 2018, in this case, okay, we have two cases actually in the year 2018, but we are going to discuss the first case in detail, not really in detail, but the summary of it. The cases in 2018, we have the case of Datuk Haris Saleh and Datuk Yong. And also we have Rao, Australian Gold Mining, and MalaysiaKini.com also reported in year 2018. For Datuk Haris Saleh, okay, the gist, okay, or the summary, the facts here, in this case, defendant insinuated, basically give some hints or suggestion implied, okay, that plaintiff was responsible, okay, for the death of 6 politicians back in year 1976. Actually, the suits was between 2 former chief minister of Sabah, okay, after this. And then for the case of Australian Gold Mining, plaintiff claimed that the 2 videos and 3 articles of the defendant allege that the gold mining activities use cyanide, okay, causing illness to villages and environment. So actually, these 2 cases are important, significant, because why? They finally settled the confusion between QP, qualified privilege, and Reynolds privilege defense. Okay, and also dwell on the defense. We also have another categories of another type of defense, which is reportage, related to Reynolds privilege actually, but it is distinct, it is different, even though they are related. Okay, let's go to this case. Datuk Muhammad Haris Saleh and Datuk Yontek. I tried to Google actually to know what's the position of these 2 people. So Datuk Haris Saleh was the 6th Chief Minister of Sabah, while Datuk Yong is the 10. Okay, 10. Is it 10? 10 Chief Minister of Sabah. Okay. So now Datuk Haris was suing Datuk Yongtek. Okay. It all started from the speech by Tengku Razali because he recalled, okay, the sad incident in year 1976 in which 6 ministers died, okay, including the then Chief Minister of Sabah, okay, at that time. So now Datuk Yontek, okay, was saying that, well, I mean, he's the president for this political party, SAPP. So he said SAPP wants to file on 666 tragedy reopen. In the year, want to reinvestigate what happened, what actually happened in the tragedy. Okay, and what's the real purpose? Okay, after so long, okay, with intention to remove all doubts about the true causes. And then in response to this, okay, in response to the statement by Datuk Yontek here, Datuk Haris Saleh 2 days later, okay, he issued a press statement of his own and he disputed the accuracy of the accounts given by Tengku Razali. He disagreed. And then he challenged Datuk Yong Tek, okay, to repeat their remarks, okay, because Datuk Yong Tek was representing their political party, okay, and accusation, more specifically and openly, okay, because what Datuk Yong Tek was saying was that there's a basis to reopen due to new info, okay, where Datuk Yong suggested that Razali was trying to tell the people, okay, when Tengku Razali made the statement, okay, recalling said incident whatsoever, certain hints, suggestion here, okay, if we were to reinvestigate, reopen the case, okay, maybe nothing new will come out of the reinvestigation, or maybe something big and explosive will surface. This is the remarks from Datuk Yong, okay. And Datuk Yong also spoke about past incident, crime, okay. This is some hints, okay. And unexplained incidents, and went on to talk about assassination of Kennedy, Martin Luther King, and Benazir Bhutto. So impliedly, all the hints, all the by way of inference, okay, not really direct, okay, here. Okay, what do we learn? Okay, basically now, on top of qualified privilege, we also have Reynolds public interest defense, and we also have the defense of reportage, all actually usually relevant to journalism, even though not limited to, but most of the time it is important for them. Okay, so for qualified, we refresh. Okay, for qualified privilege, usually it is applicable for smaller audience, okay, where there is mutual interest between them. Okay, and then if there is any malice, then qualified privilege will be defeated, cannot be used, okay, cannot be applied successfully. For Reynolds public interest defense, it is applicable to wider audience, okay, meant to protect public interest, and then must satisfy the 10 criteria for responsible journalism, and no need to show malice whatsoever. Okay, I mean not relevant to prove malice whatsoever. And then for reportage, another defense, okay, here usually it is meant for journalists, okay, to protect journalists, provided that the report must be fair, okay, disinterested and neutral, okay, without embracing or garnishing or embellishing the allegation. It has to be neutral reporting. Then only journalists can use this particular defense, cannot be biased whatsoever, okay, cannot have any inclination towards any sides when the report was done. So, and whether they are all related, are they different, are they distinct? Yes, they are. Okay, all these three defenses, it has to be pleaded, okay, on its own, and not even alternatively. Just choose one. You want to you want to defend your case under, is it under QP, is it under Reynolds, is it under reportage? Choose one, okay, not in alternative, only one, the most relevant one, okay, the strongest one, okay, to defend the case of defendant. And actually, there are two articles written by Dr. Farhin in respect of this. Both are available in current law journal, CLJ, but our IM library, we don't, previously we subscribed, but then we discontinued the subscription because of very expensive, okay, subscription fees. So now we cannot access CLJ online. I'll try to get a copy of the article from the author, from Dr. Farhin, in case you want to have a look at both of the articles here. Okay, the last slide, okay, here. And then federal court in Datuk Haris case, okay, the federal court made it clear that this is the quotation, okay, the fact that the material was of public interest does not allow the newspaper to drag in damaging allegation which serve no public interest. So we cannot simply justify, okay, the reporting by saying, oh, this is for public interest, because sometimes whatever allegation which is so damaging, it serves no public interest at all, okay. And then that's what federal court said, okay, in the case of Datuk Haris just now, okay, 2018. And as far as Malaysian law is concerned, currently we have Media Council Act, but still at bill stage. It's not yet passed as an act, okay. This is actually to to govern, okay, the freedom of media in doing reporting, basically. Okay, that's all the for supplementary notes on qualified privilege. Okay, I stop share. Hopefully you have benefited from the explanation. Assalamualaikum warahmatullahi wabarakatuh.